Good afternoon and welcome. For those of you who are joining us for the first time, this is our monthly educational webinar series with local experts. Before we begin today's session, just a few reminders that we are recording today's presentation and that the recording link along with today's presentation slides can be found on our website, dukefamilysupport.org, under the Caregiver Connections tab. After the speaker has presented, we will have an opportunity for Q&A with Jonathan. So please feel free to post any questions throughout today's presentation in the chat box for us to funnel at the end. And if there are any tech issues, please also feel free to post those in the chat box, as our staff is also monitoring the chat for any tech issues. And I will now turn things over to Bobby to introduce today's speaker.
Thanks, Janelle. Welcome, everyone. It's wonderful to see so many of you here today, see some new faces, and see some folks who we know from participating in our program. I'd like to give a shout out to Lynn Cohen, who I see is on the call today, and acknowledge that Lynn has been a volunteer with our program for over 10 years. Lynn is a retired social worker who's been co-facilitating Memory Makers with us. Glad to see you here today, Lynn. We're really glad to have Jonathan Williams here with us today. Jonathan is an attorney with Clarity Legal in Chapel Hill and a well-known face and friend to many of us on the call, as he has presented before for Caregiver Connections. And today, Jonathan's going to talk about some issues that sort of are, as he mentioned, fall sort of in the gray zone. And without further ado, I'm going to turn things over to Jonathan to talk to us about, what tools families can use when things are not so straightforward.
All right. Thank you, Janelle, and thank you, Bobby, and thanks everybody for being here. It's been, I don't know, probably about 1.5 years since I've done one of these, and I'm really happy to be back. And let me just jump in because there's a lot to talk about, and I want to leave plenty of time for Q&A. First of all, here's who we are, Clarity Legal Group. We're a law firm. We do estate planning and elder law and estate and trust administration, and that's pretty much it. We don't do other kinds of areas of law. We just stick to that niche because we are passionate about it and we like being good at it. So that's us. And if you ever need to find us, we're in right across the street from Metamont, basically next door to the Friday Center, you might say, in an office complex called the Exchange at Metamont, if you know where that is. About, I don't know, half a mile from the Durham city line. Our audience today, I know, are caregivers. We've got a great passion for caregivers. We do presentations for caregivers at different events around the Triangle and have done it for years. There's no way to say how much we admire the kind of work that caregivers do. A lot of them do it without pay, and they do it because they love folks and they want to show their love and act out their love. And I'm in awe of the people that can do that at personal cost. So first of all, thanks for everything that you do. But we're thinking of you in this presentation as someone who wants to help. You've got a loved one who needs help. They have some level of incapacity that may be very mild, it may be very severe, or it may be somewhere in between. We're going to consider all those possibilities today. Maybe resisting help. I'm sure if I were in the room and I said, yeah, sometimes your loved one that you're caring for may resist your attempts to be helpful to them. I'm sure we would see lots of nods in the room for that. We do see that a lot, not only in everyday human interaction, but particularly with dementia patients. They may or may not have legal capacity. And one of the things you'll hear me say again later is just because somebody's been diagnosed with a cognitive impairment or dementia diagnosis doesn't necessarily mean that they don't have legal capacity to act for themselves. They may still have that, and we'll talk about what that means a little bit later. They may be doing things that harm themselves, right? They may be writing a check to every charity or televangelist that comes across the TV commercial, or they may be taking healthcare risks that are out of character, so to speak. But generally, we're speaking to an audience today that I think wants to help, who wants to be helpful in that situation. So my first advice to you is a bit self-serving, but you won't be surprised to see the advice number one is run, don't walk to your nearest estate planning attorney, because estate planning documents can make life a whole lot easier. The powers that can be granted in a power of attorney, a healthcare directive, perhaps a living trust, can really make life a lot easier for someone who has those powers to act on behalf of a principal. It can save a whole lot of time, effort, and money that may otherwise have to be expended at a later date. So having good legal documents in place, if the person still has the ability to execute legal documents, can be quite helpful. And we'll talk about what those documents are. But you want to run, not walk, because as you know, capacity tends to get worse, not better, when we have someone suffering from dementia or cognitive loss. And as I said earlier, it doesn't necessarily mean that they don't have the capacity to act for themselves. The legal test for capacity to sign a document is, do they understand what they're doing at the time that they do it? And it doesn't have to be detailed. It just has to be a good general understanding. So to sign a power of attorney, the lawyer who's helping them sign it would need to confirm that the person generally knows the scope of what they own. Yeah, I have some bank accounts. Yeah, I've got some real estate. Yeah, I have some investments. They know that they want to have somebody in place who can manage that for them, and they want to sign a document to make that happen. If we can be convinced in a conversation that the person we're working with has those capabilities, even if they're fleeting, even if they're going to forget all about it half a day later, they may still be able to sign that legal document, and it may still hold up if challenged. So, it's always worth a shot if there's any doubt about whether your person can still sign documents or not. All right. What legal documents are we talking about? I won't go into the details of this because our topic is really not legal documents. It's really sort of looking at the gray area in between. But I'm not doing my job if I don't make sure that you know that there are documents out there that are called General Durable Power of Attorney, Healthcare Power of Attorney, Living Will, HIPAA authorization, and then, of course, a last will and testament, and maybe a living trust as well as part of the basic estate plan. But those first four in particular deal with making sure that while someone is living but incapacitated, they've expressed their wishes and given powers to the people that they trust to take care of things when they're unable to. So the power of attorney, the general power of attorney at the top there, is going to name an agent. The agent will have the power to act on behalf of the person who signed the document with respect to money, property, finances, bill payments, legal matters, sort of general legal and financial powers to act. The healthcare power of attorney, very similar concept. The person who serves here is called the healthcare agent. The healthcare agent has the power to make medical decisions when the person who signed the document is no longer able to make those decisions for themselves. Living will, that's a document where you state your wishes regarding end-of-life care. If you want to decline life support in certain end-of-life circumstances, you can do that in a living will. And then a HIPAA authorization is just essentially a medical privacy waiver that says these are the people that I want my doctors to be able to share health information with. So all those are important to do. And when it comes to the powers of attorney, it is important to think carefully about who the agent should be, who the healthcare agent should be. But in some of these tricky family situations, it can be just as important to say who's not on this document. There may be people that we don't want to have the power to act with respect to money and property. There may be people that we don't want to be able to act with respect to healthcare decision making, which may include decisions about whether to put someone in a facility or not, or what kind of caregiver to hire, or whether a care manager is needed. If we want to exclude folks from being a part of those decisions, putting these documents is important. To make sure that it's clear that they're not the one, it's somebody else. So this can be really important. But of course, legal documents don't solve every problem. In particular, the documents that we discussed give an agent or a healthcare agent the power to act, but they don't prevent the principal, the person who signed the documents, from continuing to act on their own behalf. So if I, Jonathan Williams, make a power of attorney, I might name my spouse as my agent on the power of attorney. So she could sign checks for me. She could pay bills for me. She could take care of things on my behalf as my agent. That doesn't necessarily mean that I don't still have the ability to act for myself. Just because I've signed a power of attorney doesn't mean I can't still write a check to the man on TV who said they need a couple $100,000 for this or that project. Just because I've signed a power of attorney doesn't mean that all these problems are solved. I may still be acting recklessly or acting in a way that harms my interest, and we may need other things in place. So the other big legal concept, sort of the hard and fast legal concept that we need to have a passing familiarity with, is guardianship. And guardianship is sort of the blunt force tool that the law gives to take care of things when someone loses the capacity to act for themselves. And in the world of guardianship, the term becomes competency. So the legal question to be resolved when a guardianship matter is being adjudicated is the person competent to handle their own affairs on a day-to-day basis, or do they need a guardian in place to do that for them? Now, if I made my power of attorney, I've named my spouse is perfectly fine. She's doing good things. Nobody's upset with her. I'm not doing reckless things, but I've become incapacitated at some point in the future. Does she have to go and seek guardianship for me just because I've become incompetent in her eyes? No. If she has the authority to act on my behalf under the power of attorney, she can make medical decisions for me under the healthcare power of attorney. She doesn't need to go to court and have me declared incompetent. She already has the ability to do everything she needs to do. And so guardianship is not automatic. Guardianship is only pursued when it's needed to be pursued. But when it is pursued, it can be very powerful because the concept here is if the court declares me incompetent, then I no longer act for myself. I don't have any rights to exercise anymore. The rights that I have to manage my own affairs have been given to my guardian. And it's very analogous to the way a parent is responsible for their child. The parent is the guardian for the child, makes decisions about healthcare and schooling and all things like that. Similarly here, the guardian would have the power to make that decision overriding my wishes if push comes to shove. So that's the general concept of guardianship. And like I said, it's a very powerful tool, but it's one that I would advise most people to avoid if they can. And the reasons for that is it is a very blunt tool, and it's as a result of that, it has a lot of sort of collateral effects. First and foremost, it's a contested legal matter in a court and can cause some real emotional toll on the people involved. If someone is trying to have me declared incompetent, they're going to have to serve me by the sheriff with legal papers. There's going to have to be a hearing in court. I'm going to be upset about this probably. It may be contested by other family members. So it can really be difficult emotionally for everybody involved. It can cause problems within the family dynamic. And so we don't want to do guardianship if we don't have to for that reason. Secondly, the court's in charge. We don't know for sure if the court's going to declare me incompetent or not. We don't know for sure who the court might decide is going to be the guardian. And so there is some uncertainty involved there. If instead we do legal documents like a power of attorney, then the person gets to decide for themselves who takes care of things for them. But if we leave it to guardianship, the court may make a different decision. And so that uncertainty is something we would like to avoid. And then, of course, anytime you go into court, it costs money. You got to pay court fees, filing fees. And then, a lot of people will ask an attorney to represent them when they're going to court to make sure that it's done right. And I don't know if you've heard, but attorneys cost money, sometimes quite a bit of money, particularly if this guardianship is contested. And it can be contested in a number of ways. The person who is alleged to be incompetent has the right to hire their own attorney to make the case that they are perfectly fine and they don't need a guardian. And that will be an expense. that will be paid by the ward, the person who's being alleged to be incompetent. Similarly, if I'm going to contest it and you know I'm going to contest it, you might want to hire a lawyer to make sure that you make a good case that a guardian is needed. And of course, if your sibling also wants to be guardian because they think they're the ones that should be in charge, they might hire their own attorney to say, wait a minute, this other person who wants to be guardian is the wrong choice, and here's why, and I'm the right choice, and here's why. And so everybody can lawyer up, and when everybody's lawyered up and we're having to exchange evidence through discovery and prepare witnesses to testify as to all these different facts you want to prove in court, all those costs can add up into the tens of thousands of dollars very quickly. And so we don't like going through guardianship if we can help it, simply because of the cost associated, the literal money cost associated with it. But of course, sometimes you need to have guardianship. It's not always avoidable. And you may anticipate some of these bullet points already from what I've said already previously. But if I've become incapacitated and I just can't sign legal documents anymore, and now somebody needs to manage my affairs, but I haven't given anybody the power to do it under a power of attorney or something like that, there's really no option in a lot of cases. Guardianship just may prove necessary just so that my affairs can get taken care of. That's the whole point of it. So that's sometimes when it's necessary. Secondly, if I do sign a power of attorney, but I'm acting recklessly and doing all these things that are contrary to my best interest, maybe a guardianship is necessary not to give the guardian power that they didn't otherwise have, but to take my power away to act on my own behalf. And so sometimes it's necessary for that reason. Or if I've named a power of attorney agent in a document, but I'm undermining them or resisting them or doing things contrary to what they're trying to accomplish, or maybe even trying to revoke the power of attorney due to some misapprehension or paranoia that I may have. Sometimes it's necessary to do that, just sort of clear the way so that the agent or guardian can act without interference. And then finally, sometimes guardianship is necessary if I've named the wrong person. If I've got two kids and I named the one who's not responsible, or the one who's taken advantage of the situation to their own benefit, or otherwise acting in a way that's inappropriate, my other child might seek guardianship over me in order to remove the ability of their sibling who might be a bad actor from being able to act. So sometimes these things do prove necessary. And from here, starting at the next slide and going all the way through the end of the Q&A, we're going to be operating in that gray zone where, are we going to need to file for guardianship or not? Well, I don't know. It's a gray area sometimes, and you don't always know for sure if it's necessary or not, or if it's the easiest path or not. So we're going to be sort of living in the gray area after this. But let's talk about some of the non-legal tools that are available for you. What kind of soft strategies might you have when your loved one can't sign documents anymore? Are the things that you can do? What about when your loved one has signed documents, but they're being resistant to your help? What can you do? What can you do, and how can you be effective? Also very important to most people is how can you make sure that you're not exposing yourself to liability unnecessarily or recklessly. So the first set of things I will talk about, I've got to say, are a little bit outside my main area of expertise. I'm an attorney and I know how the law works on these matters. But a big important skill is being able to deal with someone who's got a dementia illness. And that's not always easy to deal with. And I'm not a professional at that per se. I'm not a behavioral health specialist. I'm not a geriatrician. I'm not a geriatric care manager or anything like that. But it is helpful to have some understanding of what you're dealing with when you're dealing with a dementia patient. And of course, in my line of work, I've had lots of clients with dementia illnesses. And I'll say, flexibility and a positive attitude are going to go as far as any other quality you might bring to the situation. People with dementia illnesses can exhibit paranoia. People with dementia illnesses can show confusion, can show failure to understand, can understand incorrectly, can get wrong ideas in their head, and they have trouble getting rid of those wrong ideas. And then, of course, memory problems, right? If they think something is one way, and then you say, no, it's not that way, it's this other way, and you solve the problem in the moment because you correct their misapprehension, but then 10 minutes later or half a day later, it comes back and you've got to deal with it again. And those qualities of this particular category of illness are make it difficult to do this kind of work for people. But rolling with the punches, so to speak, being flexible, keeping a positive attitude. Let's say your parent never signed legal documents, and you're helping them, and they've got a power bill that's got to be paid. And so you've been helping him, you've been watching the mail, you see the power bill come in, you pull the power bill out, you pull out the checkbook, you say it's time to pay your power bill. You might even write the check out for them. You write who the check is for, what the amount is, you take it to them, you say, here's your power bill, here's how much you owe. I wrote a check, it's in the same amount. If you'll just sign it, I'll mail it off for you. That's the kind of thing, that people do for loved ones all the time. But you may have a loved one who says, no, that's not right. I already paid that bill last week. I'm not doing it again. Or you're gonna go and you're gonna erase the payee on this check. You're gonna put your own name in there because I know you've been stealing money from me. Or any other kind of resistance that you may get to trying to help pay this power bill, which may be perfectly unfounded, and you know better, and you're just going to have to roll with the punches. There's going to be days when you're just not able to pay the power bill because you're not going to be able to get them to sign that check. And having a positive, to be able to come back 3 hours later with the same attitude and say, well, I've got your power bill here. Here's how much you owe. I've wrote out the check. Would you like to sign the check? And coming at it with that same fresh attitude is going to be really helpful. And persistence, knowing that sometimes it's going to take several tries. And then, one thing, and I learned this when I was in law school. I was part of the elder law clinic at Wake Forest, the late, great elder law clinic at Wake Forest, which they don't run anymore. But we got to work with some dementia patients. And the thing I learned from the clinician that stuck with me the longest is, you can't, you got to let them live in the world that they live in. And if that includes misapprehensions or paranoia or whatever, you're not going to be able to argue them out of having this dementia illness. And it's going to be difficult for them and difficult for you if you're not able to just say, okay, I'll come back another time and revisit this issue some other time. So again, that's not my primary place of expertise, and I'm sure you've had other speakers that can give you a lot of these soft skills on working with folks with dementia, but that's really important. A little bit more in line with the kind of work that we do. How, if you're assisting a loved one and you're helping manage their finances, what kind of things do you need to look out for? Well, first of all, you want to be organized and you want to keep good records and you want to keep assets separate. Those are the key pillars. So first of all, if you're helping someone manage their finances, you never want to mingle your finances with their finances. If they've created a joint account, maybe that you and they share so that you can be on the account with check writing authority. You never want to put your money in that account. Just keep their money in that account. You never want to commingle, because commingling assets between you and the person you're helping is only going to muddy the water and make it harder to prove if somebody comes out later and says that you were taking advantage of your parent or loved one, or that you were negligent or reckless and not taking care of things. So keeping everything separate is very important, as well as keeping good records of everything you do. You write a check, make a copy of that check or take a photo of that check. Keep record of the bank statements when they come in. Make notes on transactions that you think might come into question later. And then, of course, organizing. We have, and we can help you get this if you want. We created this book a few years ago, and we kind of self-published it. And it's we call it the Caregiver's Guide. The full title, The Ultimate Caregiver Guide: How to Provide the Best Possible Care in North Carolina. We have these books that we prepared really just for our clients, but we're happy to share them with the community that just have some tips in there about getting into someone's papers and what do you need to keep and what do you need to get rid of, and how many years of tax returns should you keep, and how many years of bank statements do you need to keep. But getting organized is very important, and then keeping good records of what you do and making sure you keep everything strictly separate. Joint accounts, I mentioned that earlier. This is a strategy that can work if you don't have legal documents. If you do have legal documents, don't do joint accounts unless you're married to the person you're helping, because joint accounts have a lot of downsides. They basically run a lot of risk of unintended consequences. If I have a joint account with my daughter, because my daughter helps me pay my bills, and I just keep my monthly income in there, and it's paid out every month to pay my bills, that's not a big deal. That's not a big problem. That can be quite helpful, particularly if I never did a power of attorney. But if my daughter has some sort of legal issue, if she has to declare for bankruptcy, if she gets sued, if she has some creditor come after her, well, the account that she's on might be attached by her creditors and might get reached by her creditors. And so anytime I'm putting someone who is not my spouse on an account of mine, I'm exposing my assets to their liability. So there's some danger to that. Another big danger with joint accounts is just accidental disinheritance. I might have that account that my daughter is helping me with, and I just intend to only ever pay bills with that account and not really keep savings in that account. Well, what if I need to move into independent living or assisted living sometime later, and I decide we need to sell the house to pay for that level of care? Well, where are we going to put that money? We'll need to put it in that joint account so that my daughter can access it and use it to pay the cost of the care. What if I die the next day and all the proceeds from the sale of my house is in that joint account? Guess who inherits the joint account? My daughter. She's the only one who's going to inherit that account because it's joint with right of survivorship. And so what about my son? Well, my will might say I want my daughter and my son to inherit equally from me, but now we've got this joint account that's passing just to my daughter, and the will's not going to supersede that, right? The right of survivorship on the account is going to take precedence. My daughter's going to inherit that money, all of it, even if it's the entire proceeds from the sale of my home. And my son might not be too happy about that. My son might decide, I think my sister took advantage of the situation and disinherited me of a big chunk of what I was otherwise going to inherit. I think maybe I need to file a lawsuit to see if I can recoup those funds. I haven't had that happen in my practice, but somebody I worked with at a prior firm had that happen, and it got pretty ugly. So joint accounts are not the best solution because of those things. I would much rather the account be owned by the person who actually owns the funds, and have the daughter or son or whoever is helping only on there as power of attorney. That way, it's not an ownership interest. It's not a right of survivorship. It's just purely you're on here as agent. You have the ability to write checks for the benefit of the person you're helping, but it doesn't expose the assets to creditors, and it doesn't do these other things. Also, when you're helping a loved one, you want to figure out who the adverse parties might be. You know, in the scenario I just mentioned, the potential adverse party is the brother, right? You might be the sister, you might be helping mom and dad, you might be on a joint account, but you need to understand if things go belly up or if things go sideways, who are the people who might be trying to hold me accountable? And it's often the other people in the family who might otherwise inherit some of these assets. And so those are the folks that you'll want to stay in touch with. You know, if we are going to do this arrangement where we're selling the house, we're going to put the money in the joint account, only one of the kids is going to be on there. We want to be really upfront with the brother about that and say, hey, we're going to do this thing because it's the only way to do it. It's the way that I'll be able to continue to pay bills for mom and dad. I want you to know that if dad dies and this money is still in here, I'm going to inherit it all, but I'm going to share it with you. And, you know, you might even write out a memorandum of understanding just so that everybody's on the same page about what everybody's intentions are, as a way to make sure that we're not alienating someone who might have an axe to grind later, but instead we're bringing them in. That's not always possible. You know, sometimes siblings don't agree. Sometimes siblings aren't going to be receptive to this kind of stuff. Sometimes siblings aren't going to be able to sign on the dotted line and say, yes, I'm comfortable with this situation. Let's do it. And I assume we're going to have some questions that are going to land us in a lot of those gray areas. But being aware of who these potential adverse parties are is really important, and seeing what you can do to document what you're doing and protect what your actions from scrutiny that might otherwise try to prove that you were taking advantage of the situation. And then finally, if you're not comfortable with those risks, right? If you don't think that you can count on the good faith of a potential adverse party, and you would rather have the authority granted to you under a guardianship, you know, there are going to be situations where yes, guardianship is expensive. Yes, it could get messy, but the other alternatives are too risky or too unwieldy or just not workable at all. And so sometimes guardianship is just going to prove necessary. You know, working with an attorney to help you judge when you're in that situation and you need to file for guardianship might be helpful. But some of these are just going to be judgment calls that there's not a really easy black or white answer on. So that's sort of my frame of these issues and how they tend to come up. And I know there were some questions that came in prior to the presentation that I got a little bit of a preview of, and they're all going to be thorny, I'm afraid, but I'd be glad to see what kind of questions we have in the group that might be illuminating to the rest of us.
Sure. Well, we can start with some softballs, Jonathan. So one, how does one determine if they need an elder law attorney, I think, versus another type of attorney, or just in general? How do you make that decision that, yes, I need to consult with specifically an elder law attorney?
Sure. I think anytime you're dealing with powers of attorney, wills, potentially trusts, it's worth going to someone who has a specialized practice in that area of law, particularly estate planning. So I think anytime you're dealing with any of these issues, you should at least be talking to someone who dedicates a large percentage of their practice to estate planning itself, because you'd be surprised. You know, we had somebody over the summer that we worked with whose son was a lawyer, worked in healthcare, and the son sought guardianship against mom and dad we were working with mom and dad, the son just had very little understanding of how it works, didn't understand that his parents had the right to hire an attorney, um, misunderstood so much about the process. And they're a licensed attorney, right? And so these issues are complicated enough, and the pitfalls are big enough that I think anytime you're dealing with any of these, you should be speaking with someone who has some expertise in estate planning. Elder law per se, elder law as a practice is typically thought of as dealing with some specialized subsets of those issues, including Medicaid benefits eligibility, veterans benefits eligibility. I would say that the topic of this presentation, which is more guardianship and powers of attorney and some of the gray areas in between, don't necessarily require someone with an elder law expertise, but they definitely need somebody who has some estate planning expertise. And elder law doesn't hurt, because people that are in elder law are very used to dealing with folks with diminished capacity, and are very used to some of these family dynamics that sometimes come up. And so that's what I would say in answer to that.
Yeah.
You want an estate planner for sure.
Okay. How about for thinking about different states? So sort of what you've talked about today in the context of North Carolina, does it differ much as we go to different states?
I would say not a ton. Every state has their own power of attorney statute, but those laws have been more, they've gotten more uniform over time. In fact, North Carolina in 2018 revamped their power of attorney law to bring it more in line with what other states are doing. Guardianship laws are a little bit less uniform. In fact, some states don't follow the same terminology. If you follow pop culture, you may have heard of the Britney Spears case from the last year. She was recently she was under a guardianship that was terminated because the court found that she was now able to manage her own affairs. But in California, where she was, they don't refer to it as guardianship; they refer to it as conservatorship. So the terminology can differ from state to state, and sometimes the legal standard of what it means to have competency can be a little bit different. When I was in law school, famously, New Hampshire had a very high bar for obtaining guardianship. And the joke was, they really take that live free or die motto very seriously, because you have to really be pretty bad off before a New Hampshire court would find that you need a guardian. And so different states can vary their legal standards a little bit, but in general, these issues obtain all over the place and play out in a lot of similar ways.
Okay. So if I have a parent currently living in another state, but they're going to be moving to North Carolina, there's already paperwork from the other state. Would you advise that we just have that reviewed in North Carolina when they arrive?
Yes, in general, yes. The states are going to honor one another's documents for sure. So if I signed a power of attorney in West Virginia and now I'm moving here, if it was valid when and where I signed it, it's going to be honored by North Carolina. So in some ways, the answer is no, you don't need to have it reviewed because it's going to be valid. But on the other hand, well, now you're living in North Carolina, and so documents that you drafted when you lived in West Virginia might be tailored to specific things about West Virginia law, the way West Virginia powers of attorney are structured, the way the law is structured. A West Virginia will might be tailored to laws about how West Virginia estates are administered that may be different from how the laws act here. So while the power of attorney will certainly be valid and honored here, it may not meet all the needs here because the laws may vary enough that it makes a difference. But in particular, I think about the healthcare directives. I will always advise that somebody get local health directives if they can, simply because it's not the legal issues as much as it is the practical issues. Um, the point of these documents is not necessarily for them to be legally valid. The point is for them to work, and the point is for them to work easily. And so if you show up to the hospital and you're trying to make decisions on behalf of somebody under a or under a healthcare proxy that was drafted in New York State, well, we don't even call it a healthcare proxy here. We call it a healthcare power of attorney. And it's just going to look way different. And the doctor's going to look at it and they're going to say, well, I don't know exactly what this is. And they're going to have to send it to their legal office or their ethics committee or something like that. Whereas if you show up to the hospital and you've got a healthcare power of attorney that was done in North Carolina that looks like everybody else's healthcare power of attorney in North Carolina, that looks like the 10 other healthcare powers of attorney that doctor has seen that week, it's much more likely they'll say, yeah, okay, here it is. I know how this works. I know who the healthcare agent is. Let's go. And so it's the practical aspect more than the legal aspect. And for the health directives, those are freely available on the North Carolina Secretary of State website. They have links to the statutory healthcare directives, and you can get those and just print them off and fill them out before witnesses and a notary. We prepare them for our clients when we're doing estate planning work, and we tweak them a little bit from what the state form says because we think we know a little bit better. But we tweak them only vary a little bit, and if cost or even expediency is important, getting the state prepared forms are really good.
Okay, thank you. If you have durable power of attorney in place, is it required that, in this case, we're thinking about dementia, as someone's dementia progresses, that a doctor or someone write a note to say this person is no longer able to make their decisions? Is that required to sort of get the power of attorney rolling, or how does that work?
It depends on what the document says. And there's no law on this. It just depends on what the document says. So a lot of attorneys will draft the powers of attorney that say this power of attorney is only effective when a doctor determines that I'm unable to manage my own affairs, or when two doctors agree that I'm unable to manage my affairs. And if the document says that, then that's what we got to do. We got to get a doctor to write up the letter, or we got to get two doctors to write up the letter. And who do we have to convince? We have to convince the bank or the insurance company or the cable company or whoever we're trying to work with and say, I have the power to act on behalf of this other person. Here's the document. And they're going to say, okay, well, it says you only have power when the person's incapacitated. So do you have proof that the person's incapacitated? Then you got to, send that. And who knows how they're going to process that? They're not medical experts. Are they going to send it to their legal department in, Kansas City or whatever? You don't know. So we don't do that a lot in our practice. We tend to just say this power of attorney is valid. As soon as you sign it, you name an agent that, I'm in my 40s. My power of attorney says my spouse is my agent, and she's my agent. She could sign documents for me now because I've given her that power. And that way, when push comes to shove, when the time comes, if I'm incapacitated, she just shows that document. It says she's got the power to act. We don't need a doctor to get involved, and we don't need a third party to acknowledge medical evidence that they may or may not have the ability to process quickly.
Yeah. Okay. Thank you. When determining capacity, how might someone's complex psychiatric history impact your ability to determine capacity?
Oh yeah. Well, it all is it's very fact specific. So, we need to have reassurances that the person has the rudimentary understanding of what they're doing. And that's not always evident just by sitting down and having a conversation with them. Sometimes their mental health history or their history of dementia or diminished capacity can really impact that. And so, yeah, there's definitely times when we're saying, we're really not sure here. We've had 2 or 3 conversations, but we're not 100% sure. We need to get an expert's opinion here so that we've got more confidence that our client has the ability to sign this document. So for sure, there are times when we're consulting with a geriatrician or we're consulting with a mental health specialist so that we can get not only the expert opinion, but the opinion of someone who's had a patient provider history with this person to let us know if their opinion on it. Ultimately, it's a legal question. Do they have capacity to act or not? It's a legal question. It's not a medical question. But obviously, the medical evidence is highly relevant to whether they have the capacity to act for themselves or not. And it's hard to say in general. Sometimes it depends on the circumstance. Sometimes we meet clients every day that are perfectly fine. We're not asking them to submit letters from their doctors that they're able to sign documents. Those circumstances can come up in different ways, and it's hard to know. But I hope that addresses the question.
Yeah, thank you. So when you do complete paperwork, again, durable power of attorney, when you do have those forms completed, do they go into a database where maybe other attorneys would be able to see that Natalie Leary has paperwork created, or no?
In general, no.
Okay.
There are a couple of things that might look something like that. For example, that there are some occasions where we record the power of attorney with the Register of Deeds office. Before we updated our law in 2018, that happened a lot because the way the law was worded made a lot of financial institutions want to have the power of attorney recorded in order for them to feel confident that it was valid. The law has since changed on that. The law now says you only have to record the power of attorney if you're using it in a real estate transaction. And so you record it so that it's part of the chain of title in the real estate transaction. That's the only reason the law will require recording of a power of attorney. Some people record it anyway, just because they want it to be public. Sometimes financial institutions still want you to record it, even though the law has changed. The banks don't always change their policies as quickly as the law changes. And so there are still some times when people will record it, but it's less and less frequently since they changed the law a few years ago. On the healthcare documents side, there's no public database of healthcare directives. The Secretary of State's office does run a health directive registry. And so you can send your healthcare power of attorney, your living will, to the Secretary of State's health directive registry, and they will basically it's a document storage service that the state provides. So they'll scan it into their system. They'll send it back to you with a little card that says, if you need the document in the future, here's how you can get it. And so that way you can log into their website and enter your little code and get a copy of the document. But that's not a public thing. You've got to have that code to get the document. So it's really just a service that the state provides its citizens. It's not a public database that can be searched.
And that kind of leads me into this next question. We hear about this more than folks might realize, where I have established power of attorney, let's say with my parent, and then it's all set up, and then maybe my sibling or another family member comes and takes my parent to an elder law attorney and has new paperwork created. So now mine is sort of voided, right? And theirs is active. What first, I guess it's a layered question. First, what is there immediate action that one should take? Like, do you go to that attorney and have a conversation? What's the first step?
Well, first of all, I should say you can have more than one power of attorney. And just because you do a new power of attorney doesn't necessarily mean that the other power of attorney has been voided. Sometimes people forget to revoke the old one when they do a new one. So just keep that in mind.
Okay.
But yeah, if your loved one has done a new power of attorney and revoked your power of attorney, and you believe they didn't have the legal capacity to do so, right? I mean, if they had the legal capacity to do so, you got to live with it, right? They made a choice. Maybe you don't like their choice. It's their choice, right? This is America. They can do what they want. But if you believe that it was done under undue influence, duress, lack of capacity, and that the new documents really aren't valid, then this is a big gray area because you might contact the bank and say, my understanding is that my parent has executed a new document, but my parent did not have the legal capacity to sign that new document. They were taken to a lawyer by a bad actor, and I don't want you to honor this power of attorney. I want you to continue to honor my power of attorney. And they may put a freeze on the account while they do like a fraud investigation or an elder exploitation investigation. So that's one thing you can do, is to contact the financial institutions and say, heads up, you might scrutinize these documents and whether they're valid or not. You might go to your parent and say and see if you might have them sign a revocation of whatever they just did, and send that back to the other parent, to the other participant. I don't know. This is one of those cases where sometimes legal action is involved. If someone is trying to access a bank account. So you might take the position, well, my parent revoked my power, but it was not valid because they didn't have the capacity to act. So I'm going to take the position that I'm still agent for my mom. And now this other person has come in and is trying to get access to her assets. And as her agent and on my mom's behalf, I'm going to take legal action to protect my mother from this interloper who's trying to get access to the assets. And it would be on those grounds that you might file some sort of legal action, either for declaratory judgment, which is basically where you're asking a court to say, declare whether this document is valid or not, or it might be in the context of a legal action against the other person for committing fraud or misappropriating funds or something like that. Or it might be in the context of guardianship, right? This might be an occasion to say, okay, well, since there's a question about whose power of attorney is valid, why don't we just bring this to court and have a guardian put in place, and we'll just let the court decide who the right person is to be guardian. So there's a number of different ways that you might handle that, depending on the circumstances. But I would say, if you're asking, what's my first step, probably contact the financial institutions and let them know that there's a controversy here, so that they can lock up the account and do their own investigation.
Okay. How would you receive a letter that the power of attorney has been revoked, or how do you find out if they actually took that step?
Yeah, the power of attorney is only revoked if the agent gets notice of the revocation.
Okay.
So if you're the agent under the power of attorney and your parent goes and revokes it, the revocation is not complete until you receive notice of it. And so, yeah, by law, you're gonna get notice, or else it didn't happen, legally speaking.
Okay. So another case that sometimes we'll hear, again, folks have in this situation power of attorney paperwork in place. It comes time they do need to make a move for their loved one to a long-term care community. And maybe their loved one saying, I'm not going to stay here. I don't want to be here. And in some cases, the facility has said, hey, you should pursue guardianship in an effort to make them stay. Is there a power of attorney that is sufficient to sort of exercise this decision to move to a long-term care community?
It's the healthcare power of attorney. So the healthcare power of attorney is going to say, If I am unable to make and communicate my own healthcare decisions, then my healthcare agent has the power to make those decisions for me.
Mhm.
And those decisions are going to include admission or discharge to any facility, including a residential facility.
Mhm.
And so, technically speaking, the healthcare power of attorney should give the healthcare agent the power to admit them to a facility and keep them there, even if it's against their wishes. But the problem is, you've got to have firm medical opinion that the person is not able to make and communicate their own decisions. So you've got to have really clear documentation that her physician has said she's not able to make decisions. And then you've got to have a facility that's willing to do that, right? You've got to have a facility that's willing to say, yep, I know you don't want to be here, and I know you want to run away, but your doctor has said that you don't have the ability to make this decision, and we answer to your healthcare agent because it's your healthcare agent that's making these decisions now. And facilities aren't comfortable with that. They're afraid of liability. They don't like the headache and the hassle. I would not be surprised if the facility is just saying, we need a court order here, because they're just not comfortable relying on a healthcare power of attorney. But there's no legal reason why they couldn't. I think it's really more of a comfort issue that they would prefer to act. They would feel protected from liability if they're holding someone in their facility pursuant to a court order, as opposed to simply, well, some doctor said she can't make her decisions anymore.
Right. Okay. Okay. And the advice that you gave around joint accounts, does that, what if we're married? So it's two spouses on a joint account. Does that same warning that you issued apply in those cases?
Generally, no. If you're married to the person, it's all those issues of having joint accounts generally go away, except sometimes in the case of like blended families, right? So for a married couple that's first marriage, all their kids are kids they have in common. This idea that all the money is going to go to the spouse and not going to pass through the plan to the other people in the family is probably not a big deal, because everybody would expect that the spouse is leaving the assets to the other spouse, no problem. But if you have children with the expectation, hey, wait a minute, we were supposed to inherit the money, they signed a prenup or something like that, and now all the money's going to the spouse instead. Some of those same kinds of sort of misunderstandings or potential accidental disinheritance could come up in that kind of context. But our standard line on joint accounts is, unless you absolutely have no other option, don't have a joint account with anybody other than your spouse. It's typically not a big deal with the spouse in most cases.
Okay. If on my power of attorney, I have a primary and a secondary listed, how does that work? Is it, does the secondary ever get to sort of trump what the primary decides, or is it in order? How does that go?
It depends on what the document says. If you're right in what you say, then no, the primary agent is the agent. The secondary is just the backup. The secondary doesn't have any power to act as long as the primary is still serving. But there is another way to structure it, which is you can make co-agents. And so if you have co-agents, then they both have power to act. And if they disagree with one another, then the document may have some way to resolve that, or it may not, and we may have an issue. But if the question is accurate, that we've got a primary and a secondary, primary trumps secondary always.
Okay. Gotcha. So if it is truly primary and secondary, not co-agents, then until the primary is no longer able to act in their role for whatever reason, then the secondary is just in waiting.
That's right.
Essentially. Okay. Okay, great.
And,
There was
let me say real quick, if the secondary believes that the primary is acting inappropriately,
Mhm.
their recourse would be to maybe file for guardianship or maybe file an action to have the person removed as agent. But at that point, you might as well just do guardianship. So
Okay. There were lots of questions around how to get your book and folks who don't live
Yeah.
locally. So curious, how do we do that?
we have pretty good access to the post office, and we've got we're happy to field inquiries about the book. We kind of sort of just self-published it for our own clients and our community, and so we have it when we go to events, and we've given it out to our clients. So you won't find it on like Amazon or something like that. But we're happy to field inquiries. Do you guys have our contact information on?
We do. Do you have a slide? I was wondering, well, it just had your email on it.
Well, let me find it.
Let's see. We can pop that up for folks.
All I have is our address. You don't even need our address. I can put it in the chat.
Okay. Yes, and we can make sure that folks have it. Just as a reminder, as he puts that in the chat box, we will post the recording for today along with the PowerPoint with Jonathan's slides. For folks who would like to forward it on or watch it again. All right. Well, Jonathan, thank you so much just for your patience with all of our questions. I know we didn't get to everyone's specific situation, and we recognize that, but we appreciate what we could get through today. I'm going to bring in Bobby and just see if she has any closing thoughts for us today.
Well, again, thank you, Jonathan. This was really helpful, very interesting. These are complicated issues, and really appreciate your time with us today. For those of you on the call, we have Caregiver Connections once a month. Next month, our presentation will be by Daniel Potter, who's a geriatrician here at Duke, and he's going to be speaking about the newly approved Alzheimer's drug, lecanemab. That's going to be on February 16th at 1 o'clock. That's also a Thursday. You'll get information about that in our e-news and then also in some emails. And somebody is asking if you could please repeat the name of the book, Jonathan.
Okay, put it in the chat. It's the Ultimate Caregiver Guide.
Great.
It's the only book we got. So if you call the that's the book.
Well, thank you for making the book available. Thank you again for this really helpful presentation, and wonderful to see everyone here today. Take care, and we'll see you next month.
Thank you.